What property is even subject to probate? That's the first thing we've got to figure out. So there are really two major ways that this can happen. We can either have property that is left in the individual name of the deceased person. That's the stuff that goes to probate. Or we can have property that passes automatically by either by operation of law or through a contract. So what do I mean when I say passing through a contract? So this would be like your 401k plans, your life insurance beneficiaries, your transfer on death. To an extent, you can call that a contractual operation. So what's happening there is that the beneficiary is set on these things and it is transferring outside the probate system. Doesn't have to go to court at all. It just goes to whoever the beneficiary is. The other way stuff can transfer outside of probate is by operation of law. What do I mean by that? So in this context, we're talking about usually forms of co-ownership. So think about joint tenancy with right of survivorship, tenancy by the entirety for married couples. Basically what those do is if somebody dies as joint tenant owning property, it will automatically pass to the other co-owners. No probate, happens automatically. Okay. The other form of co-ownership is tenancy in common. And in that scenario, when a co-owner, a tenant in common dies, their interest in the property does fall to their probate estate and does have to go through probate unless they have some other mechanism to transfer it, like a beneficiary deed or something like that. Okay. So the probate process in Missouri is, in some ways it's straightforward. In other ways it's crazy and arcane. But at a very high level, the steps are as follows. So one of the first things we need to do, if there's a will, we need to get that admitted to probate. That means we need to file an application with the court. This has to be done within 1 year of death in the state of Missouri, or that will is completely useless. Most people are shocked to find this. I'm shocked every time I say it, that in the state of Missouri, if you do not file a will and admit it to probate within 1 year of death, it becomes a useless piece of paper. Okay? So getting a will admitted to probate timely is one of the most important first steps if there is a will. That will needs to be witnessed by two people. That will needs to be notarized. Well, it doesn't have to be, but it makes things a lot easier if it is witnessed properly and notarized. The will is then in most cases going to control who's named as the personal representative. Are we going to need to get a bond? Are we going to allow independent administration, or are we going to have to go to court and get a supervised court order for every little thing that we want to do? Those are the main things that the will is going to deal with, in addition to distributing the property, obviously, to designated beneficiaries under the will. In Missouri, there are a number of different types of probate that you can proceed through, depending on a few variables, like how big is the estate? Is it over or under $40,000? When did the person die? Was it over a year ago or less than a year ago? In Missouri, like kind of the default administration that most people might think of in the probate context is a full estate administration. But in fact, these only happen when the estate is valued at more than $40,000 and it's been less than 1 year since the date of death. Those are the most common scenarios where we end up in a full estate administration. This usually takes at least 9 to 12 months, sometimes longer. And most of the reason for that is due to the creditor claims period. You got to wait at least 6 months and leave the estate open at least 6 months to allow creditors a chance to come and file a claim against the estate if they want to. Now, if there is no will in a full estate administration, we've got to figure out who is allowed to serve as representative. And there's an order of priority in who can do that. It starts with the spouse, if there is one, goes to kids, if there is one, if there are any. And if there are no kids and no spouse, then it can start going out to collateral kin, like siblings, parents, and then from there, aunts and uncles, nieces, nephews, things like that. Okay. But it starts with the spouse and then the kids. In Missouri, as in most states, the representative before taking office is going to have to get a bond. What's a bond? A bond is basically an insurance policy that protects the estate from mismanagement. So if the personal representative decides, I'm going to take this money and I'm going to run off to the Cayman Islands or Bermuda and, pocket it and enjoy myself and, forget the heirs, right? Well, that's what the bond is there for. So if they walk off, what a aggrieved heir or a creditor can do is they can file a claim against that bond to be made whole. The bond company is insuring against that risk. So you have to pay a premium in order to get appointed. They'll underwrite you and decide if you're a good risk. And a lot of time, and many people just get turned down, either because they have bad credit or for some other reason. The other thing to know is that in a full estate administration, that's either going to be an independent administration or it's going to be a supervised administration. So an independent administration means you don't have to get a court order for every little thing that you do. You can handle it a lot outside of court. It becomes a lot more like what a trustee would be allowed to do, to manage the estate property outside of court supervision. Essentially, in an independent administration, we file some paperwork to open the estate and get what are called letters of administration, if there is no will, or letters testamentary if there is a will, which is kind of the badge of honor, the certificate of authenticity and authority that is given to a personal representative when they are appointed. And the only time you need to file anything after that, you got to file an inventory at the beginning to say what assets are in the estate. But then you just wait around a little while until it's time to close, and you file some closing paperwork. Sometimes an independent administration can be easy. Okay, usually it's really not all that bad. Supervised administration, on the other hand, is a lot more work. Usually there are a whole lot more applications that get filed with the court, but closing is usually the most laborious part of the process. Closing a supervised administration requires careful auditing, accounting of every transaction that went in and out. You have to get vouchers and verification of every expense and piece of income that came in and out of the estate, and it has to all be run through the estate auditors and approved by the court before you can close the estate. Lots of applications, lots of consents and signing, and oftentimes there are hearings in court. It's a much bigger ordeal. But as I mentioned, one of the first things that happens after getting appointed in a full estate administration is that you have to file an inventory. That's an inventory of the property that was owned by the decedent at the time of their death. So what's the stuff? What's the stuff that's got to go through probate, right? This is kind of where we make that determination. We decide, well, these things passed outside of probate, probably don't need to worry about those. But this is the stuff they owned. This is the stuff that creditors need to know about. This is the stuff that the family members need to know about. This is the stuff that we need to get a court order to distribute to the heirs of the estate. Now, that inventory typically needs a lot of detail. You need to know account numbers. You need to know VIN numbers on vehicles, real estate, property descriptions from the original deeds. You got to get all this stuff. You got to do a lot of due diligence in documenting and verifying the assets that are actually in and belong to the estate. Once this inventory is filed, like I said, in many cases, you're sitting around. You're waiting for maybe a creditor wants to file. Maybe we need to administer a business. Maybe we need to worry about non-legal things like getting a house sold or selling off other assets and opening a checking account for the estate so that there's a place to park any money that comes in, rolling over checking accounts, savings accounts into an estate named account. In addition to that, that is part of what sets off a 6-month creditor claims period, right? We wait until that 6 months have elapsed from the date that publication of notice goes in the newspaper. So once you get appointed representative, the court is going to require you to publish in the newspaper and send some mail to anybody who needs to be notified of the estate. And when you do that, that starts that 6-month clock that says, hey, if you've got a claim against this estate, you need to file it now. And Missouri is very interesting and different in certain ways with regard to its probate claims process. Many creditors do not get paid at all. Credit card companies, healthcare companies, debt collectors, they almost universally, if the representative is being properly represented by a counsel, almost universally those claims get thrown out. We had a claim of $50,000 in credit card bills. We got thrown out that was levied against a probate estate because the creditors filed their claim and never showed up to court. They didn't show up to their hearing. And in Missouri, in probate, if you notice a creditor's claim for hearing and that creditor does not show up, the judge in most cases will order that claim is dismissed and cannot be recovered. So it's a great way that we can add value to our clients by protecting more of the estate assets from creditors. Now, there are a couple of creditors that this doesn't apply to, right? The federal government for income tax or other tax-related claims, we have to file some special paperwork to make sure that we can tie that up as quickly as possible. The state of Missouri, if we have tax bills and things like that, they're not bound by the time limit to file. The way in which they can be bound and barred forever is if we wait 1 year from the date of death. If nobody opens an estate, let's say somebody died in December or January, and nobody opens an estate until after the next January, 1 year, over 1 year later, an estate cannot be opened at that point. You can only do short form probates when it's been more than 1 year since the date of death. And that leads to some interesting planning opportunities. Sometimes people were on Medicaid, and there's a huge Medicaid bill for their care. That's another thing a lot of people don't realize. In the state of Missouri, as in almost every state, I think it is virtually every state in the country, in every state in the country, if a deceased person was on Medicaid at the time that they die, in most cases, depending on the value of the estate, the value of the claim, Medicaid will try to file a claim against that person's probate estate to recover the amount of the bills that were paid throughout their life. So like, let's say that there was $1 million expended on somebody's long-term care cancer treatment. It's usually not that much, but let's suppose it is. Medicaid will file a claim against the estate to try and recover that money back. It'd be like if your insurance company, let's say you had private insurance and you secured coverage through your insurance for your cancer treatment. It'd be a lot like if that insurance company came after your probate estate and said, hey, remember that time we helped you out when you were really sick? Yeah, we'd like all that money back. Well, that's how state governments work in recovering Medicaid amounts paid. A lot of people have no idea that how this system works and how dramatically it can impact families, especially families of lower means and families of color. It's just the way it is, unfortunately. But we can work around that rule, right? Because if nobody files a claim within 1 year and nobody opens an estate within 1 year, you can file for an expedited probate administration after 1 year of death. And at that point, no creditor is allowed to be compensated, including the state of Missouri and Medicaid. The only time that they're allowed to be compensated after 1 year is if an estate is already open, if somebody has already filed to open an estate within time. But if nobody files, you can actually bar many, many kinds of creditors in the state of Missouri. Now, in Missouri, a full estate administration, the legal fees involved in that are the same fees that the personal representative is allowed to take for doing the job. All right. And that's a percentage of the estate value that is set based on the value of the estate. It's based on the value of the real property that is sold under order of the court, as well as any personal property in the estate. It's a percentage formula that you have to apply to figure out what that fee is going to be for the attorney, and the same fee can be taken by the representative. Okay. If an estate is under $40,000 in the state of Missouri, you can file what's called a small estate affidavit. This is a dramatically expedited probate process. If you can show that the value of the probate assets after subtracting any debt, so it could be a mortgage, could be a lien on a vehicle, could be credit card debt. If you can show that the value of the estate is lower than $40,000 after subtracting debt, you can file an affidavit. And in many cases, you can get that case administered in anywhere from 2 weeks all the way up to about 6 or 8 weeks, depending on what the court wants to see, depending on what kind of hurdles need to be jumped through. But in most cases, it's going to be dramatically faster than a full estate administration. Another means of probating an estate is called a determination of heirship. This can only be done after 1 year of death, but it can be done for assets of any size, no matter how large. You could probate $1 million in a short form administration after a 1 year of death using this mechanism. And in a determination of heirship, basically what we do is we file an application with the court. We get a hearing date set. We notify everybody. We put some stuff in the newspaper. We hold that hearing. I ask our clients some questions on the record, and we get an order entered. And 9 times out of 10, it is that easy. Okay, there are times where it is more complicated, particularly where we actually have disputes over the heirship. And in those cases, it can be different. But in most cases, we don't need to worry about that. And if the only asset in the estate is real estate, it gets even easier. After 1 year of death, most people don't realize this, but after 1 year of death, when somebody passes away, their property in the state of Missouri falls to the heirs automatically and instantly as a matter of law. And you might be asking, well, why do we need to go to probate then? The reason is because we need to have a court declaration that creditors have been satisfied or are barred. We need to have a court order to show a clear title, because many title companies are not going to accept your sworn statement that title is clear until they know that either probate has resolved and creditors have been paid, or that probate doesn't need to happen and never happened within the 1 year time period. Because if it's been over 1 year and no estate has been opened, the property is already passed to the heirs, and all we need to do is execute an affidavit, and we can record that with the Recorder of Deeds office, because after 1 year, creditors can't be paid anymore. So there's no risk of a cloud on title anymore at that point. So as long as the affidavit is accurate, we've identified the decedent, we've identified all the people and the heirs and who they are, then we don't need to worry about it, and we can clean up the title that way. Much faster, doesn't even require probate at all, but it only works with real estate. For people like minor children of the decedent, spouses of the decedent, creditors of the decedent, especially children who paid a funeral bill, we can do an even faster method of probate. What we can do in that scenario is we can use the spousal allowance, the minor's family support allowance, and various allowances to claim the probate estate immediately, rather than going through probate, rather than opening an estate and dealing with the whole administration. What that application does is it says, hey, judge, look, so-and-so died, they left some property, their spouse is still alive, the property's less than their spousal allowance would have been, so let's just give it all to the spouse. That's what the application does, okay? And we can terminate a probate administration sometimes in just a month or two, or even faster, depending on the scenario, okay? And this tool is also really effective when we have creditor claims, particularly funeral bills. The most common one is when we have a child who pays a creditor funeral bill. We've seen some big ones, but I mean, suppose they paid $10,000 or $15,000 toward a funeral, and they find, oh shoot, dad left a checking account with $12,000 in it. Well, they already paid $15,000 in a funeral bill, and a funeral bill is one of the top priority claims to get paid back first in the state of Missouri. So what that tells the court is, look, your bill is one of the top priority creditors. It's more than the value of the estate. You can just take the checking account. So it's another easy way of gaining access to a probate property when we otherwise would have to go through a probate process. Now, another issue is dealing with avoiding probate entirely. Because if we can avoid this process entirely, how can we do that? Well, there are a number of different ways we can do that. The simplest, fastest, easiest ways are through tools like transfer on death designations on your checking account, savings account, brokerage account. Beneficiary designations on your retirement plans, 401ks, IRAs, things like that. Beneficiary deed on real estate so that will automatically and instantly transfer at the moment of death. All those things keep you out of probate. So does a trust if you have assets in a trust. And there are pros and cons to doing simple transfer on death designations versus a trust. We'll talk about that some other time. But avoiding probate entirely is often a goal. Now, that being said, it's not always appropriate to avoid probate entirely. It really, really depends on the state that you're in. It depends on the circumstances of the family. Sometimes there are families that they really shouldn't be avoiding probate. Like, we really need a judge to supervise this process, or else people are going to not get along very well. And in those kind of scenarios, sometimes it's not appropriate to have a trust. Sometimes it's not appropriate to have a private administration of the estate unless you're involving an independent third party like a trust company or a bank or a private fiduciary. Sometimes it's really just not appropriate to name a family member trustee in those kind of scenarios. So it really depends on where you're at, where your family's at, what kind of family they are, and how well they're going to get along. Sometimes probate actually does make sense.